partner, an American patent attorney, and former engineer who loves visiting Valencia and Spain. And also, he's here with his wife, Shana. Thank you very much for coming, by the way. So, Micah is right now studying Spanish, but his Spanish is not that great, so the talk is going to be in English, just so you know. He was granted the degree cum laude by the University of California at Berkeley, majoring in electrical engineering and computer science. And during and after college, he worked in circuit design in Silicon Valley, California. He earned his law degree from Lewis and Clark College in Portland in 1981. Much later, he served as adjunct professor at the law school, teaching patent law and patent litigation. Micah represents technology companies ranging in size from new startups to large public companies. And he helps clients in the Western US and abroad protecting their innovations, mainly obtaining patents, including US utility and design patterns, trademarks, as well as foreign patents and design registration, that's all. Micah also helps clients acquire, protect, and monetize their intellectual property through a variety of IP transfers, licensing agreements, and other transactions. He also advises clients on avoiding infringement of IP rights owned by others. And since BML started back in 2011, Micah has been helping us with the legal part. So without further ado, please Micah join, and let's start with the talk. Thank you.
Thank you. Buenas tardes. That's it. No more Spanish. Okay, let me see how this thing works. Okay. So good afternoon. We're going to talk about intellectual property and protecting IP, especially for startup companies, especially for tech startup companies. Just the legal disclaimers, the fine print, I'm not representing you and don't rely on anything I say. Okay. So I got a lot of material here. It's got a little bit like drinking from the fire hydrant. Just try to, if you catch a few helpful points, if you remember a few things, it's all good. All right. A little bit here about market strategy, and really the issue is why do we care about IP? And I'm not going to read the whole slide to you, but IP is particularly important for smaller companies, maybe in a little different way than larger companies, right? When you're a small tech company in particular and you're starting out and you've got some great ideas and some new ways to address things, and that's often all you have, right? That's intellectual property. You've got ideas, you've got inventions, you don't have customers yet, you don't have product yet, but you've got intellectual property, and we'll talk more about what forms that takes, and you want to protect it. And it's going to help you eventually in raising money. It's going to help you in negotiating with other companies. It can be used, once you get patents, of course, you can use them offensively, we call it. In other words, to stop others from using your inventions without permission. We also use patents defensively, and that's where your company gets sued by a patent holder. And then you say, well, wait a minute, we have a bunch of patents over here that you either may be infringing or may be interested in using, okay? So you can do a cross-license agreement, a kind of a peace treaty. But if you don't have IP to trade, you can't do that peace treaty, all right? Okay, let's move on here. VCs, meaning venture capitalists or other investors, invest in IP. So again, if I'm an investor, or I'm a venture capitalist or what have you, and you want to come and make a pitch to me to invest in your company, well, what are you going to show me? Your product's probably not finished, right? You don't have customers. You don't have an operating history economically. You've got a bunch of great ideas. So what I want to know is, how are you protecting that intellectual property? And so it's something that comes up right away. And when you're a startup company or even thinking about starting a company, you got to think about IP early on, okay? And I'll get into a little bit later about some of the legal rules that you must follow in terms of timeliness. Okay. So make sure it's legally sound early on. Make sure your company's IP is owned by the company. How does it get owned by the company? You have individual inventors, engineers, people with great ideas, but it needs to be assigned to the company. And we'll talk a little bit about employment agreements, that obligation to assign rights to the company. Get that in place early on, all right? Co-founders, employees, again, want to sign some kind of an invention agreement. It can be a part of an employment agreement. You can have separate invention assignment agreements, but you want to nail that stuff down. What happens sometimes is companies put that off. You know, you're busy, you're trying to develop your inventions, and they'll put off some of these legal formalities, and then, you know, some time goes by, and now some of your team happens to leave. Somebody, you know, they want to do their own company, or they get hired by a different company, and they're walking out the door, and they haven't assigned those rights over to the company. So that could lead to some problems. Okay. So we're going to talk about these 4 kinds of IP today. Going to go pretty quickly through trademark and copyrights, and then we're going to get into more depth on trade secrets and patents. Okay? All right, trademarks. Everybody knows about trademarks. They're everywhere. It can be a word, a phrase, a symbol that identifies a source of goods. Okay? So we see trademarks all the time. That's a trademark right there. ML is a trademark in the upper right. So probably the main thing besides getting a really cool trademark is to make sure that it's not going to be too similar to someone else's, right? So when you're early on, you're trying to figure out your mark, or you may design an original logo, do some research, do some Google searching. There are databases in Europe and in the US trademark office to find anything that might be similar, okay? So to try to get it cleared, and if nobody else has it, then you start using that mark in your materials and register it. So trademark protection arises from use of the mark in commerce. I know I'm forgetting to move the microphone. What do I mean by use in commerce? So trademark usage, kind of a technical term. It means if you're selling goods, physical goods, you got to have the trademark on the goods or on the package, okay? To be trademark use in commerce for goods. We have well, that's an ML, but under the ML, there's an apple, right? There's an apple on the computer. All right, so it's on the goods. But if you're doing services, maybe you're doing accounting services, maybe you do legal services like I do, various things, consulting services, you can still have a trademark. Technically, it's called a service mark. And so then use in commerce means, well, we put it on the website, put it on your business cards, right? You will put it on all kinds of materials in connection with your services. Like if you're sending in an invoice for consulting services, put the trademark on there for your services. So the use in commerce is how you get trademark rights. Do you have to register? It's a good idea, but the rights fundamentally arise from use. Okay, it's good to register because it gives notice to the whole world that we're claiming this mark, this trademark, okay? But actually, if you had, let's say 2 people applied for the same trademark at the same time, it's going to be who used it first in commerce is going to win. Okay, that's moving on. Okay, everybody knows that trademark, right? Don't use that one, bad idea. That little orange swoosh, okay. Does anybody recognize that trademark? Nobody knows that trademark? Come on, we're in Spain, right? Okay, there you go. That's the trademark for Rafa Nadal, the tennis player. All right, talk about copyright a little bit. So, what's copyright about? Well, let me go forward here. These are just some examples. If you write a story, you write a book, you write an article, you create a painting, you take a photograph, all these kinds of original, often artistic works are protectable by copyright. Okay. So why do we care about copyright? Well, it comes up in various different ways. Let's say your website. You've got all kinds of great content on your website. That takes a lot of effort, and it's protected by copyright. Okay. Software. Software is protectable by copyright. Now, I'm not going to go off into open source and that whole thing today. You know, copyright and copyleft and all that. But to the extent you're not doing an open source, to the extent you're creating what we call proprietary code, it's going to be protectable by copyright, and you may want to register copyright. Okay. dramatics works, TV shows, that's all copyrightable subject matter. So, and there's the Berne Convention we'll get to, covers that pretty much worldwide. All right, so what's more important for my purposes is what copyright is not, okay? It gives you a right to prevent others from copying, okay? That's cool. But what it doesn't give you is this. Copyright does not protect the idea, a procedure, a process, a system, method of operation. In other words, technology, not protected by copyright, except the software, okay? So when you have a new invention and you want to protect the idea, the concepts, that's patent. That has to be done by patent. So just to illustrate about copyright, let's say you go down on the beach and there's a palm tree and two kids are playing with a ball. It's lovely. You take a picture, okay. You put it up on the wall. There's a nice picture on the beach and the palm tree and the two kids. Now, I come along and go, wow, that's pretty cool. And you know, I'm an amateur painter. So I go down to the beach, set up my easel, get my paints, and either looking at your photo or just keeping it in mind, I go and paint a palm tree and two kids on the beach playing with the ball, okay? So, copyright infringement from your photograph? No, because it doesn't protect the idea, okay? I just created a new original painting. I own the copyright in my painting. You own the copyright in your photograph, but you can't own the idea of a picture on the beach with a palm tree, okay? All right, now, I like this picture. What's the next topic? Right, trade secrets. Okay, well, let's talk about that a little bit. Trade secrets are important. A lot of senior executives, over 80%, say they're critical, they're essential to your business. Half the executives in one survey said it's more important than patents or trademarks, okay? So why is that so important? Well, again, let's go back to early on in the company. You've got some founders, you've got some smart engineers getting together, talking about some great ideas. Okay. Right there is intellectual property. Is it protectable? Yes, as a trade secret. Okay. You haven't even filed for any patents yet, but there is value in that information. Okay. So how are we going to protect it? Well, there are trade secret laws. There are criminal laws. There are civil laws. America, Spain, everywhere. And what those laws require is that you have to do it yourself. And I'll tell you a little bit more about how you do that. But first, what's the scope? Almost anything can be trade secret, can be protected under the trade secret law. So it might be, who are your vendors? Your cost information, okay? Consultants that you use, your customer list, your product plan, software roadmap. What do you know? What do you got? Where are you going? What do you hope to do? What's in your plan for the next 5 years? That's all trade secret information if you keep it a trade secret. You don't register it, you don't file with the government, and it doesn't cost anything much, okay? It's what we call self-help. You are the ones that are going to protect your trade secrets. Okay, how do you do that? Internal policies and procedures. You're going to figure it out, you write it all down, and this can be an employee manual or just a set of policies that says, hey, here's how we're going to protect our trade secret information or proprietary information, okay? Here's how we're going to manage files on our servers. Here's how we're going to manage access, logins, authentication. Here's how we're going to prevent copying. Let's get the process and procedures down. And part of that is identifying the trade secret information, right? If you want something to be protected, usually it's going to get reduced to some kind of documentation, and that'd be paper, can be in the computer, but it's marked proprietary, it's marked trade secret all over it, so there's no question, okay? All right, so develop the internal policies of how you're going to handle things, how you're going to inventory trade secrets, and get it in the employment agreements, and use non-disclosure agreements to keep that information confidential. Okay. Yeah, I mean it's like these little disk drives now, right? They hold a gazillion gigabytes. Somebody can take a little drive that big and walk out with an awful lot of data, right? Okay. So All kinds of information is protectable, but you got to take steps to protect it. Put it in your employment agreements, your policies, use non-disclosure agreements. New law in Spain that just came into effect this year. Pretty much what I've been saying is pretty consistent, whether it's in America or Spain or other places. Information relating to any part of your business can be technical, scientific, or commercial. It's got to be secret. It's not generally known. It's not published. And commercial value and reasonable steps, the bottom one's the most important one. Reasonable steps must be adopted by the holder to keep it secret. That's in the statute. That's in the law. Okay? So how does that play out? Well, somebody steals your trade secrets. Maybe it's a former employee. They go to a competitor. And you want to stop this. You sue the competitor, you sue the employee, you go to court. Now you're in court. Now you're up on the witness stand. And then the defense lawyer says, so tell me, Mr. Plaintiff, what did you do to protect that secret? Well, we kind of told people to not let out information. I may not do it, okay? You want to go into court and say, here's the stuff, it's all marked confidential, it's marked proprietary, and here's the employment agreement, this person agreed, they signed to not take this information. You got to prove that you took those steps, and then you can get some remedy under the law, okay? So as I said, in terms of employment agreements, there's various things go in employment agreement. I'm not an employment lawyer, but you want to have an IP section in your employment agreement. So in the IP section, agree to keep trade secrets confidential, comply with those procedures we talked about. Sometimes what we'll do is we'll have some trade secret procedures and attach it to the employment agreement. It says, okay, yeah, I've read that, I understand it, I'll abide by it. So it's like an appendix. Yes, I'll report any theft or a leak or anything that I learn of, because time is of the essence. We talked already about obligation to assign. And non-compete, a lot of places non-compete agreements are illegal, so I'm not going to go into that too much. Okay, so support your trade secret protection in your employment agreements. Don't sign the NDA and forget about NDA being non-disclosure agreement. So we use these often, right? You need to either talk to a vendor, you need to talk to a consultant, even talking to a potential customer. If you're going to disclose confidential information, you want to have a non-disclosure agreement. Sometimes it's one way, but most of the time they're mutual, both ways. You're going to share some information. So if you don't get a non-disclosure agreement, well, you're just leaking out trade secret information. So, and why do I say it? Here's what I mean about don't just sign it and forget about it. What I mean is you need to continue to utilize that NDA properly. And how to do it, it's in the NDA. This is a good example, okay? A definition of confidential information in the non-disclosure agreement itself, and it says, okay, it can be any non-public, yada, yada, underline, which the disclosure identifies at the time of disclosure as confidential. Okay, so right there, hey, on this paper, see, it says confidential, it says proprietary, you put it in the footer. So you identified it as confidential at the time of delivery. And what if you just have a meeting, oral disclosure or visually, and you're talking on the whiteboard? Okay, well, under this agreement, and I think it's a good example, it says, disclosure identifies such information as confidential and or proprietary at the time of disclosure, and, key word here is, and within 30 days, you're going to follow up, reduce it to some kind of tangible form or in a paper or in a computer file, but capture that stuff. Sometimes it's just take pictures of the whiteboard, capture it, and then you got it in some kind of tangible form, and then you're going to identify it as we said above. So in other words, you're going to follow up within 30 days, say, hey, we had that meeting, remember? Here's where we met, here's who was there, here's what we talked about, here's the slides, letting you know it's covered by our non-disclosure agreement. Okay, so then you get some protection. Too often people go into meetings and they just don't, and they say, oh, we have an NDA. But if you don't follow the terms of the NDA, you're going to have problems. All right, erase the whiteboard. This just comes back to the theme of trade secret protection is self-help, okay? A million years ago, I worked at Xerox, and they had signs like this in the meeting rooms, erase the whiteboard. Just a little common sense. All right. Good. We're doing good. Automated trade secret protection. This is just a paper one of my partners published. There's a link in there. He wrote a little paper about could we automate trade secret protection? And he kind of laid out some ideas about how to do that, to actually programmatically inventory trade secret information, coming up with a systematic way that things are described. And once you have an electronic inventory, it's a database, it's pretty easy to kind of track who accessed it, when did they access it, why did they access it. So it's an idea that you can think about whether you can automate some trade secret protection. Okay. Talking about patents. So, as I mentioned earlier, patents protect inventions, they protect concepts and ideas, and the fundamental requirement for patent application or to get a patent is that you have to describe not just your idea in sort of a general theoretical way, but how do you do it? We call it an enabling disclosure. Okay. So the test is enough disclosure to enable somebody who works in that field to go and read that and say, oh, okay, yeah, oh, good idea, yeah, I get it, okay, and then they can go and build it, okay. So you lay it out for them. Sometimes we use flow diagrams and various things. So it doesn't have to be so detailed as like lines of code, but it's enough detail to explain how it works so that somebody who's a programmer could take that and they could go write the code, okay. So, and we're going to come back to that, particularly in the context of provisional patent applications. Because when we talk about provisional and non-provisional, that enablement requirement is basically the same. All right. So let's see here. Patents, lots of countries. Yeah, we still have patents are a national thing. Each country has their own patents, pretty much. What's happened over quite a few years, what they call patent harmonization. They have a lot of meetings between government representatives and patent offices around the world, and they're always kind of tweaking their laws to be a little more consistent. We're trying to be more uniform worldwide, but we don't yet have a worldwide patent. So we're still dealing with this multiple jurisdictions. But the general principles are pretty consistent across jurisdictions. Okay. So claim drafting, I'm not going to go into that too much right here. So this idea of a limited time monopoly, of course, that's what it is. A patent is a grant of a legal monopoly by the government, right? How long does it last? 20 years from your first filing date. It's a long time. And then it goes into the public domain. Okay, now remember you wrote all that enabling description. You have contributed to the state of the art. You've contributed to the knowledge of mankind because it's all published. And the patent cannot be extended or renewed. 20 years, you're done. And there's some technicalities, but that's the basic rule. Okay, so in 20 years, that technology is in the public domain. All right. Now, the right to enforce the patent, of course, doesn't arise until it's granted. How long to get through the examination process? It's not so good. About 3 or 4 years would be typical. Okay. In the US right now, it's about 18 months till your first examination report. Then you're kind of back and forth with the examiner for another year or so. I think the average total pendency is about 3 years. Europe's worth, EPO, the European Patent Office, that's probably more like 4 years. Okay. Now, it's not all bad news, and I'll tell you why. The patent application is published 18 months after your first filing date. All right. So you still have that trade secret protection for 18 months, and then it's going to publish, unless you pull it out and don't publish it. So you got some time to kind of make that decision. You can't keep it secret and get a patent. You have to go one way or the other, but you've got a little time to make that decision. Okay. Sometimes we'll decide for various reasons, no, let's abandon the patent application before it publishes, and we're going to keep trade secret protection. So there's that trade-off. All right. Let's move on toward filing on time. So most countries in the world have what's called absolute novelty requirement. What that means is to get a patent on an invention, it must be new. Novelty is sort of equivalent to new. Well, what do you mean new? It's not out there. In other words, it has not been published or described in any publication or any website or PhD thesis or a patent or anything, anywhere in the world. Okay? If it's out there, anywhere in the world in any language, it's no longer passes that test of absolute novelty. Okay? So that's a key point. Now, in the US, there is a grace period only for the inventor. So if I'm the inventor and I have an invention and I go out and publish it, okay, I want to tell everybody, I'll just put it on the website and publish my invention. Okay, boom, immediately I can't get a patent anywhere in the world except in the US because I just blew the absolute novelty. Right? Now it's published, it's not novel. I also gave away trade secret protection. Okay. Now, so in the US though, if you can still file for a patent within 12 months, this grace period, if you published it and you're the inventor. The good news is about publication. Yeah.
What happens, you have published it, but you haven't patented it yet?
Say it again.
So you say you first publish it, but it's not patented yet.
Right.
And you do that in the US. And somebody in China does something very similar, but not the same. What happens? The person in China can patent that invention, even though it's super similar to that one in the US, but not the same.
Right. So it's that similarity, of course, is the key question. So the thing that you published, that's out there, is what we call part of the state of the art. So when the Chinese person files their patent and they go into examination in the Chinese patent office, they're going to look at that publication as prior art, as state of the art, and say, okay, well, what's new and different over that art? Okay, so if it's what we call non-obvious, a substantial improvement, they might get a patent in China, not on the fundamental idea that you published, but on their improvement. Does that make sense? Mm-hmm. Okay. Okay. So as I say, so for most countries, you don't have that grace period. You can't publish or have a public disclosure. You lose your patent rights. You need to get a filing date, and we're going to talk about in a minute, before public disclosure. Okay. If you're going to have rights anywhere outside the U.S. All right. So this idea about the first to file. Let's say you invented something, but you kept it trade secret, like I've been suggesting, but somebody else publishes it, or someone else files a patent application. They don't know, you may not know about them, they don't know about you, because you kept it secret. Okay. Well, they can get a patent, okay, because it still passes the novelty. It's not out there, because you kept it secret. They could get a patent. Okay. So there's some more details about that, prior user defense and some other things, but that's the general idea. Okay. Why do we care? I mean, we touched on that earlier. The remedies for patent infringement, if you can get a patent, aside from licensing revenue and using it defensively and all that, but the primary remedies are twofold: reasonable royalties and injunctive relief. Okay. Does everybody know what that means? Reasonable royalties, not so much. So a royalty is a payment. In the simple case, let's say you sell goods. You sell tennis shoes, and somebody infringes the patent on your tennis shoes. Okay, then through the litigation process, the jury or the judge might decide, okay, you need to pay them a royalty, and maybe it's €1 for every pair of tennis shoes that infringes the patent. Okay, so that's royalties. And that can add up. And a lot of litigation over how much is the appropriate number for royalties. But the other thing is called injunctive relief. What that means is an injunction is an order by the court to stop. Stop what? Stop importing, offering for sale, selling the infringing product. Okay? So, like last year, when the court orders Samsung to stop importing smartphones into the United States because they infringe Apple's patents, that's a big problem. Okay, so the threat of injunctive relief is a very powerful attribute, generally, of utility patents. So, and you can't always get injunctive relief. I mean, there's different factors and all that. But anyway, you can get money and injunctive relief. So let's get on to developing that portfolio a little bit. Keep filing new patent applications as you further develop your technology, new embodiments, new features, new applications. I mean, I've done some work where we had a core idea, but the client kept figuring out new ways to use it in different, use cases or different industries. And there were some, there's a lot of details about that. So we continue to file and obtain additional patents that are directed to different uses in different industries, okay? And that can be a really good strategy. All right, now, and multiple applications and priority claims can be combined. So we're going to talk in just a minute about provisional patent applications. And one of the things you can do is you can file multiple provisionals, but you can put them together when the time comes to do a non-provisional or file in Europe. You can just put them together, combine them into a single filing, save a lot of filing fees and things like that. Okay, so let's get into the provisional patent application a little bit. You're going to see in a minute why the provisional has some real advantages. And why we're here talking about that, it's a U.S. statute, the provisional patent. Yeah, and the reason is because it's pretty unique. I don't think I'm not aware of any other jurisdiction that has the same thing as what we call a U.S. provisional patent application. But what's important about it is that it is recognized under international treaties that I'll get to in a minute by virtually everybody, every country. Okay, so you file your provisional patent application in the United States, and the U.S. doesn't discriminate, doesn't matter where you live, nationality, or anything. But you file a provisional patent, and you get you get your filing date, you get a receipt. That date now can be used around the world as your priority date. All right. What's the importance of priority date? A couple of things. One is, once you have that priority date, then you can go and publish. No problem, okay? So if you choose to publicly disclose your invention, but the day after you got that filing date, you're fine, okay? I'll show you why in just a minute. All right. And provisional helps control cash flow. So let's look at this a little bit more. This is just, who's using provisional patent applications? About half of the U.S. patents that are granted, about half of them started as a provisional, okay? You don't have to do provisional, it's an optional thing. You can just file a regular, we call non-provisional patent application. They cost more money, which we'll talk about, but the advantage is if you file a non-provisional, that goes right into the queue for examination, right? The provisional patent application doesn't get examined. It just sits there for a year. So I'll explain. So this filing date I keep talking about, it's also called a right of priority under the international treaties. But basically it's saying, you described all that stuff, remember the enabling description, you got a good description, and you filed it in the U.S. Patent Office, and you got a date. And, all right, fast and simple, but must be complete. But why do I say it's fast and simple? It's not like a formal patent application. I mean, you've seen patents probably, and a patent is just a nicely published version of a patent application. So we patent lawyers write the patent application, and eventually after examination, what we wrote and the drawings that we submitted, that gets all put together in a nice document, and that's the patent. Right? But you don't have to meet all the technical and formatting requirements for a provisional. They'll take almost anything. Okay. It can be just handwritten on a napkin. You can file that as a provisional patent application. I've done it. Actually, a paper placemat. Just as an aside, but many, many years ago, because I'm old, and I was down in Silicon Valley, people would go to lunch, they'd go to coffee, and they always had these paper placemats. And then engineers, they get out their pencil and pen, and they're talking, and then pretty soon they're drawing circuits. we take that paper and you can file it as a provisional if you need to. Now, why do you say if you need to? Well, because sometimes the client, the engineers, whatever, they're going to go to a meeting, right? Or they're going to go do a presentation, or it's going to go up on the website, maybe in 3 days. Okay, you don't have time for a formal patent application. That's okay. If you got the content in some form, just file a provisional. And you've got a year to convert to the formal patent application, okay? So does it get examined and does it get published? It's kept secret in the patent office. You can say patent pending, because that's true. And you've got 12 months to decide, nah, let's forget about it. Or, yeah, we want to invest in a real patent on this invention, okay? So that gives you a year, or you can do it sooner. You don't have to wait a year. But I had one experience not too long ago. I went into, it was a new client, and went into a meeting with some of the executives, and it was some software engineers out of the University of Washington, a very good, CS department. So they're talking about, they formed a new company, they got some investors, and they're talking about this technology. And I was asking them about, publication. And I was asking about, I need written description. I need a lot of written description. Do that enabling description. And he said, oh, it's all there in my PhD thesis. I've been doing this for a long time. And I wrote it all up in the PhD thesis. I said, oh, which is thick, right? I said, well, when was that PhD thesis published? Oh, it was about 11 months ago. Well, you remember in the US from publication, we got a 1-year grace period. We had like a week left, okay? So I took a PhD thesis, 2 or 3 inches thick. I put a cover sheet on the top, said provisional patent application, boom, we file it, we get a date, okay? Now, the content's all in there. It's not in a easily usable form, but I've got a year to take that information. I've got that date, and we then, what's the term? Sort of mine that into 5 or 10 patent applications. Okay, no problem. But they all get this right of priority. They all get that date. So they're within the grace period and all right.
And what would have happened if this was after the 12 months?
If it was after it was published?
Yeah, if you wouldn't have requested the date to apply for a patent.
Yeah. Well, it was after it was published, but it was within a year.
Yeah, but I'm asking what would have happened if it was after the year?
Oh, after the year? So it's been more than a year since publication?
Yeah.
It's too late to patent.
You cannot.
Nope, you can't. Of course, again, what's been out there published, it's in the public domain. No one else can patent it either, because it's well, first of all, they're not the inventor, but it's part of the state of the art. You can't publish something that's already out there in state of the art, right? Okay, so simple, fast to file, keep it secret. It buys you a year to help make decisions. The content is key, not the format, as I mentioned. It can be anything, but seriously, you'd like to have drawings and illustrations. You'd like to have a good narrative description. I'm not going to get into claims too much, but you put it together, you pay your $140, and you file in the patent office. And now you've got a date. And you can't change it, right? Now, 2 months later, it's like, oh, geez, I forgot to put in this part, which is kind of a cool thing. Well, it's not the end of the world. Another $140, file another provisional, put in the additional stuff, okay? Sometimes we might file 2, 3, or 4 provisionals because the client is further developing the technology. Then we will put it all together into one application as long as it's within 12 months of the first one, the earliest one, right? And I claim priority from all 4, or whatever it is. but they all have to be within a year. So effectively, it's got to be within the year of the earliest or the first filing. Now, all right, so now we know about priority date. That's the same as a right of priority. That's that first filing date. Okay, and you can't add more information after that. So when we go to the non-provisional, the regular application that's going to be examined, okay, we claim priority from the provisional. I say, look, there's our first filing date, but now we got to make it into a formal application. Okay, can I add new information? Very limited, right? I mean, after all, you have a date back here, and you're getting the benefit of that date under international treaties. So if you put in new stuff, it may not be entitled to the benefit of that date. Now, what happens in practice? Well, we push it a little. You know, we're maybe elaborating a little bit. Maybe we're embellishing a little bit based on the provisional. So we may be adding some stuff around the edges. And usually it's okay. It only comes up in two ways. One, if the examiner they're doing their patentability search, right? They want to see if it's patentable. So they conduct a search, and they're looking in the databases and articles and patents and publications, and they find one that's got, that's really pertinent, similar. And the date of that publication, guess what? It's in that year. It's after your provisional was filed, but it's before your non-provisional was filed. It's in between, okay? And it's pertinent. Well, then the examiner has got to look at your provisional and what you're claiming now and say, okay, did you have enough in there back in the provisional, because that was before this other art, did you have enough in there to support what you're claiming now? If you did, you're fine, because your date's before this guy. But if you added some stuff on the non-provisional that wasn't in here, and then you're claiming it, and then there's this what we call intervening prior art, they came in the middle, then you got a problem, right? So, because then you won't be patentable for those claims over that intervening prior art that was published during the 1 year. Now, that can come up in examination. It doesn't too often. It can come up in litigation. Okay, now you've got your patent, now you go to enforce it, and you sue somebody, and they hire a bunch of lawyers, and they're going to bring every possible attack on the validity of your patent. And sometimes the one that comes up was, you got this thing in this claim, but really that wasn't in the provisional. Now here, the defendant is going to do their own research. In other words, they're going to try to find prior art to invalidate your patent. And their search may be more thorough than the patent examiner, right? Pity the poor patent examiner. They have hundreds and hundreds of applications. They get an allotment of, 15 hours to examine the application and move on. But in litigation, you got $10 million at stake. You hire fleets of lawyers. They will scour the earth for prior art. They'll find an article that was published in Russia that no one's ever seen. They'll find it. So, moving on. All right, talking about money just a little bit. So, kind of the sequence of events. Here's your invention. Okay, it's early in the company. You got some friends and family, some angel investors. Start filing these provisional patents. That's that $140 filing fee. It's pretty modest. Now you can do a public disclosure once you filed and got your priority date. That won't hurt you. Okay. So now we're a year later, a year and a half. Hopefully you're raising some money. When you get to the end of this year, you have to do your non-provisional and or foreign filing. And we're going to talk about the PCT there in a minute. Okay, so here we got to spend some money. Then a publication, as I mentioned. So virtually all cases will be published 18 months after the provisional, the first filing date. Okay, they get published. Unless you withdraw before publication. If you just decide, I don't want it to publish, I'm not going to seek a patent, and you do it in a timely manner, you can stop publication. But if you're going to get a patent, it's going to publish. Okay. and then you get into the examination, and you can spend some money on examination and grant fees. All right. So down here, I mentioned PCT national fees. What's all that? Okay. So try not to trip over the cord here. Let's see what that's about. So there's a thing called WIPO. We call it WIPO, World Intellectual Property Organization. Anybody heard of that? No. Okay. So WIPO is a piece of the United Nations, and it's located somewhere here in Europe. I think, where's WIPO? Probably Germany or something. But anyway, they manage and implement a number of international treaties to protect IP worldwide. Okay. And so there are trademarks, patents, industrial designs. Again, there are international treaties. Many countries, most industrialized countries, belong to these treaties for protecting these forms of IP. You can go to the wipo.int and lots of information. Okay, and search tools and so forth. So one of the things they do is they administer the PCT, the Patent Cooperation Treaty. And basically it says, okay, once you have a priority date fixed, then a public use or a public disclosure of the invention will not bar patent under the absolute novelty laws for all countries that are members of the PCT. Okay? All the PCT member countries will accept, for example, that US provisional filing date as your priority claim. So now, even though you publish and all that, it's sometimes called a legal fiction. Pretend you filed back on that date, let's say in Europe. You didn't really, but under the treaty, you have equivalent rights as if you had filed on that date before publication. All right, so PCT helps applicants protect internationally. 150 member countries now, it keeps growing. You're going to file one application under the PCT, and they've got 250,000 applications last year under the PCT. Now, so there's convenience here because we take one application and you just file it under the PCT, and you establish that priority date for all 150 member countries. Okay. Doesn't mean you get a patent in all those, but you've got a date. So you're not going to be barred by those absolute novelty provisions. This is just the cover page of a WIPO or PCT publication. So there's a priority date. It goes right on there. This is that application serial number and the filing date. This happens to be a US case in June of 16. This, by the way, because I know the numbers, this is not a provisional. It's just a regular non-provisional. That can be your first filing too. You get a priority date, whether it's provisional or non-provisional. So that's in June. So then the international filing date, see, had to be within a year. Pretty close. So a year later is the international filing date. You file the PCT application, and then they publish it. This date, you'll see, is about a year and a half, about 18 months after your priority date. That's under the treaty. These see what they call designated states. These are the two-letter codes for all the member countries, members of the PCT. And it's, what is it, ES for Spain? Is that the code? No? Yeah, that's fine. Okay. So let me walk through this timeline in just a few minutes, and we'll wrap it up. So here's our priority date, and again, it can be the provisional application, which is pretty quick and easy, or it could be a non-provisional. You got that 12 months, and then you can file an international application with the PCT receiving office. Now, you don't have to go through this PCT. What it does, it defers expenses, okay? You could say, look, I only want to file in 4 countries. I want China, Mexico, Korea, whatever, okay. Okay, that's fine. Within 12 months, right here, you can just go file, we call it a direct national in the countries you pick, okay? Your filing cost varies by country, but $6,000 or $7,000 per country, so you got to pay up, okay, and get into examination. If you go with the PCT, you file that one case, and now it's in what we call the international phase of the PCT, what they're going to do is they're going to conduct a patentability search for you, okay? And you're going to get the ISR's an international search report on patentability. So the international search authorities, they're going to do that search for prior art and find everything they can find, and they'll report it to you. And they'll tell you if it looks patentable or doesn't look so patentable. So this is helpful. So you get a written opinion on patentability. And okay, and now time marches on. I won't go into this supplementary search. It's optional. We usually don't do it. The point is, you get out here 30 months after your first filing date. Okay, 30 months for most countries. There's a few variations, and I think actually Europe, the EPO, European Patent Office, I think it's 31 months. But 30 months from the priority date is the deadline to enter the national phase. So what that means is, you're going to go into the designated offices that you pick with your international application. The international application is going to move into individual countries, designated offices. Now, here you're still going to pay that $6,000 or $7,000 per country. Okay, it's just that you didn't have to do it here at the beginning. You're going to have to do it 30 months later. And a lot of people use the PCT to buy time for decision making and what countries do you want to go forward in, or not. So it's about preserving the option and deferring expense. So the PCT is very useful. Like I said, it keeps growing every year. 150 member countries. So that's PCT. Multinational patents, we don't need to spend much time on this. There isn't exactly really a multinational patent. So what's this EPO about? So many years ago, the European Community, they formed a treaty called the European Patent Convention. And under the European Patent Convention, they created the European Patent Office. And they said, look, we're going to have this office that's going to do examination for most of Europe at that time. They've added countries since then. So what they do is centralized examination. So you file an EPO application. And by the way, when you have that PCT right here, and you go in the national phase, one of these offices can be the EPO. Okay? It's treated like a country for this purpose. So you can enter the EPO from your PCT. So the European Patent Office does the examination for patentability, and when they're done, if you're successful, you get a grant. It's called a grant of a European patent. But it's not quite a patent, almost. But then you go to the individual countries in Europe. You go in there and say, hey, here's my grant from the EPO. I want this to be a Spanish patent. Okay, we'll pay some money, translate it into Spanish, and now you have a Spanish national patent. This is the same as if you had gone direct national to the Spanish Patent Office. Same thing in other countries in Europe. So it's called the validation phase. So after you get a European patent grant, you can validate in any or all the countries that you choose in the European community. All right. So it's not really, it's centralized examination, but not really a multinational patent. But then there's this thing called a unitary patent. This is ongoing right now. It's just coming into force. Some countries have rejected it in Europe, some like it. And because it's been controversial, they've been negotiating the unitary patent for years. They kind of made it optional. So some applicants, for technical reasons, may choose to go with that. So we're pretty close. Thanks for your attention, and I'm happy to take questions. Preferably in English, but Maria Jesus can translate. So, okay.
En español, lo siento.
You listen, so.
Yes.
Because I don't.
Se puede hacer una patente provisional, que esa patente provisional caduque al año y volver a realizar esa patente, o sea, pedir lo mismo provisionalmente.
Can you do a provisional patent and then after a year, when the deadline is over, you did not proceed with the patent, but then do again another provisional patent exactly with the same content?
Okay. That's a good question. So at the end of the 1 year, that provisional, gone, expired, it's gone. Can you file a new one? Yes. But now, if there were other publications during the year, other people publish things, you know, that you may not be patentable anymore. But you can certainly do that. Yeah. Okay.
Questions?
Okay.
Cuando expira una patente provisional, ¿qué pasa con esa información? ¿Desaparece? ¿Se destruye?
Even when it expires, ¿qué pasa with the información? See, so it's secret. Okay, in the patent office, we say buried. It's not disclosed. It's not disclosed. You can still, if you kept it a secret, it can still be a trade secret. Right? If the provisional, you file a provisional, you change your mind, you want it to be a secret, you just do nothing. And it expires and it's kept secret. Okay? So if you have any questions anytime, just you can find me on the internet, you can send emails, no problem.
Or we can continue the questions outside with some drinks and pizzas and snacks.
Perfecto.
Yeah? So, yeah? Good. Thank you very much.
Thank you.